things that the CJ department says, at least as it comes through my students, and that's primarily because I'm right and they're wrong. So, moving on. I don't know, I guess that wasn't that funny either. We're going to talk about these things today with a focus on more on business than just criminal law in general. We're going to talk about the elements or things you need for a crime, the broad categories of crime, and then focus in on white-collar crime, not crimes committed by the clergy. White-collar. Get it? Well, you're right. It's not funny when I record it. I don't know what it is. Maybe some technical issue. You can't hear it in the recording, but they're all laughing hysterically. Defenses that could be raised. Remember, there's defenses and torts in Chapter 4. Now we're going to talk about defenses to crimes. Go back even further to some of our first week of class and talk about constitutional safeguards, and then kind of walk you through a criminal proceeding. This is important, this slide right here. If you were going to make a note in your book or write on any of your slides or make a note on your laptop, distinguishing between the last chapter, torts, and criminal law. A lot of that's on this slide. Notice torts is one type of civil law, but not the only type of civil law. So the first distinction is who the parties are. And we've talked a little bit about this before. In civil law, it's you versus me, plaintiff versus defendant. And in a criminal case, the victim is not a party. Instead, the state, the people, are the plaintiff. And the defendant's still the defendant. And what they're designed to protect is different under wrongful act. Civil law is about protecting harm to a person, or protecting people from harm to their person or their property. And criminal law is pretty much statutory law. This is a statute that you can't violate, and if you do, you may be prosecuted for it. Burden of proof is a big one. Like I probably mentioned OJ in here before. You know, the criminal prosecution first, and the prosecutor having to establish beyond a reasonable doubt that he did it, and then later the tort action for wrongful death. And in that case, the jury found by preponderance of the evidence that he did it. So notice the different amounts of evidence that's needed. A civil burden of proof is a preponderance of the evidence, meaning more likely than not. Sometimes people say 51%. I don't like the percentometer. I don't know how that works. Like you just hold it up against the defendant and it goes, oh, 51, and then the other side gets the win. But the next one is a verdict. In a jury trial, in a civil case, usually a majority, a three-quarter majority. On the criminal side, almost always unanimous, which is good for you if you were charged with a crime and somebody's trying to decide your guilt or innocence. You wouldn't want them to just kind of like, hey, well, it looks like most of us think he's guilty or she's guilty. Yes?
If there's a hung jury, do they have to retry the whole thing?
Well, it depends. You said have to retry. Often there's a decision by the people or the prosecutor as to whether it's worth the time and effort and expense to do it. So, and the likelihood of actually not doing it again, right? If you're just going to keep kind of in this loop and, you know, it's one of those type of cases where they're just never going to be able to decide. Remedy. So, in a civil case, damages, maybe equitable relief, but the whole idea is to compensate the individual for harm. Versus in a criminal case, it's all about punishing. The example I was using last class is I'd see a lot of cases as a prosecutor where angry boyfriend busts down apartment door, charged with malicious destruction of property. Later, girlfriend comes in and says, we're back in love, and I want to drop the charges. Well, you guys remember the whole thing about, is it really the victim who's bringing the charges? No. And the other extreme was the girlfriend would come in and say, well, when he was in there, he took this, this, and this, and that's mine. oh, well, the police say it's unclear, so we didn't authorize larceny. Well, he took it, I can prove it's mine, and I want money for it. Well, looking up there and the different goals of these two, it wasn't our goal, our role, to try to get her damage or him, whichever the case might be, for whatever was taken out of the apartment, right? We were primarily focused on preventing him from running around breaking down people's doors. Does that make sense? Yeah. Like there are different interests that are being protected. Civil versus criminal law in kind of the same action. I mentioned OJ as an example. Here's a person attacking Joe as he's walking down the street. I don't know if you noticed this morning, but on Blackboard there was an important announcement about somebody who was assaulted. So I didn't notice. I just log in and go past those type of things, but then somebody said, did you see the notice? And so I logged out to look at it. But somebody was apparently walking nearby here, and somebody tried to grab them, and they broke free and got to their car. But just a reminder of your personal safety, to not walk alone at night. I guess it was Friday night around 9 p.m. Yeah, right here. Yeah. So anyway, so let's say, that happens. There could be a tort and there could be a crime. So on the right side, we're talking about this assailant. In this case, even though they didn't, according to the report, do something harmful to the person, they did assault, right? From what was described, at least. And then that would be, if the person was caught and prosecuted, in the end, that would be some kind of order regarding fines or imprisonment, or maybe some other type of punishment or treatment. And then on the left, it would be the person who's assailed versus the defendant in a civil suit, and it would be about any injuries that resulted from that. Yeah?
Who makes the decision for restitution? Say it's a crime, but there have been drunk driver hit someone, and the person has to. So who makes that decision when they?
Yeah, well, there is a little bit of an overlap, right? I mean, I'm saying like prosecutor's primary role isn't to recover damages for the victim, but there are some cases where the court orders restitution as part of somebody's sentence. And so that's statutory authority, and then whoever's responsible under the statute to enforce that. But that's a tough one, because usually somebody who's imprisoned, they don't have a lot of money, nor do they have a job, usually, to pay it, and then somebody comes looking for the restitution. Like, where is it? Well, maybe you'll have to go civilly after this person in order to recover it. So, it is statutory, but it's not always the case that somebody pays that restitution. Of course, that could also result in additional things happening to them as a result of not paying restitution. All right. Criminal liability requires two things: a criminal act and a criminal mind. Your intent has to be wrongful, and in some cases specific. But it's not enough just to intend. You have to act. Remember the Minority Report movie where the people arrest people for not doing things yet, but thinking about them? That's not how it works. At least not yet. Soon, but not yet. Until then, you can get away. In fact, I'm thinking of doing something to you right now. Are you feeling uncomfortable? It's really bad. Right? But unless I do something, it's not a crime. The statute doesn't protect people from my bad thoughts. Right? I mean, if we could get arrested for our bad thoughts, think of how many times we've got caught today, even. Maybe just me, but yeah, we need some furtherance of that. Now, it doesn't necessarily mean we need to complete the act in some cases. Like there's attempt, Like we intend to do the act and we start it, but it doesn't get finished. But we've got to do something. It's not enough just to think about it. Sometimes the law says that intent has to be specific, like premeditated murder, right? That involves proving that somebody planned out it, versus other types of manslaughter that may just require negligence or something else. And then the act. We could do an act without the intent. That wouldn't be enough either. Like we talked a little bit about that in the tort area too, between the difference between intentional torts and negligence. If I'm out front here swinging a 2x4 around and I manage to hit somebody and they start bleeding, if I didn't intend that, if it was an accident, I'm swinging a 2x4 around, maybe I acted negligently, but I didn't intend to cause any harm. Okay, so with battery in the criminal setting, I've got to have some kind of intent to do the act that causes the harm. If somebody can't prove that, maybe they could show some type of negligence. All right, so you need both those things. And without intent, there can't be a conviction. And I'd even go further to say, unless there's a statute on it, most of the time you can't be convicted of a crime. And that changes over time. I mean, there was a time where there was a question of whether you could assist somebody in committing suicide. There used to be there was no statute in Michigan prohibiting you from selling your children. There was a guy who put up his kids, his like beautiful kids for sale, and the prosecutor charges them, and then they go looking at the law, and there's no law that says you can't sell your kids. Now there is, but a little too late for me. But I love my kids. All right, so corporate criminal liability. You can't haul the building off the jail in handcuffs. So what liability do those within the corporation, employers, employees, board of directors, have is the question. Usually for corporate liability, you need the crime to have occurred within the scope of employment. What your employees do in terms of crimes off the job is usually not your responsibility. There's some overlap. I suppose if you gave them the instrument, told them to go do it, just do it on your off hours, that probably would lead to liability. Or even as a second check mark says there, failing to do some statutory duty can now be a crime. You're supposed to review financial records and sign off on them and swear that you did, and then later there's a problem. You might have some liability for that. If you're an officer or director under the responsible officer doctrine, you might have some liability. If your employee was under your control and supervision, you knew about it, you participated in it, or you didn't stop it. In some cases, maybe just even you should have known about it. So what are the different types of crimes? Well, one way the book looks at it is the difference between violent and nonviolent crimes, or violent and property crimes. I think most people are familiar with the violent ones. That's what all the TV shows are about. Murder, rape, robbery. The nonviolent crimes start real simple. Each crime has elements, things that you have to prove in order for it to be a crime. So one of the most basic ones up there is larceny. What's your book say you need for larceny? Yeah.
Take possession of it and carry it away.
Yeah, so you need to intentionally or wrongfully take personal property of another And then a lot of statutes talk about permanently depriving. In other words, you don't have to say that somebody snuck up specifically going, hee, I'm going to steal you that textbook. It's enough to come up and take it and not bring it back. So if you take the book intentionally, don't intend to bring it back, it is personal property, it belongs to someone else. In other words, you don't steal your own stuff. Steal someone else's. These are the basic elements of larceny. Now, you can build on these and make other crimes. Like, for example, how do I get from here to robbery? What else do I need to add?
Robbery is force.
Right. Force or threat of force. It's important to look at it that way because a lot of people think when they think robbery, what do you think of? Guns, right? Banks. And that is robbery. But what other types of things based on this definition could that be?
Just the threat of
Right. Give me your money or I'll punch you. Right? Or, even combinations like what if I come up to pickpocket you? Is that robbery? Yeah, there's no threat or anything yet. But what if as I try to take it, we get into a scuffle and I beat you up and take it? Yeah, it is really battery combined with larceny, which makes robbery. So that could be enough. It gets a little tricky sometimes. I remember, did I tell you about people who steal meat from stores? So one of those times when that was happening, the security tried to stop the person from leaving the store, and they got into a fight. So then the question was, could the prosecutor charge robbery because the person took the meat from the store by force? Basically you need both those things together. So a lot of time we don't think of that type of situation. We think of robbing a bank and it doesn't even have to be, you see the gun, right? Somebody could think you have one or you have the ability. Sometimes people do it with a note, whatever. I still remember in Chicago I got held up by knife point one time. And I twirled and kicked the knife out of the guy's hand. Chuck Norris stepped in and took care of things. But no, I just started making a big scene and raising my voice and everything, and a guy freaked out and took off. Later, I thought, boy, that was stupid. You just could have went, shut up, knife. But anyway, that's all you need for robbery. And then some of these other ones are variations on a theme, like burglary. What's your book say burglary is?
Breaking and entering the dwelling.
That's right. So it could be larceny, but it doesn't have to be. It could be breaking and entering with the intent to commit some crime, usually a felony, but it doesn't have to be that you're stealing something. In fact, the original common law in the book said it had to be what? Dwelling
Of another at
night. So if you did it during the day, you're cool. But night was a problem. But so now a lot of the statutes say break and enter anything, motor vehicle, home, building, whatever. Those are all considered burglary or home invasion, and depending on who's there and what you're doing, it could be an increased penalty of some kind. So burglary involves breaking and entering somewhere. Obtaining goods by false pretenses, so kind of taking those ideas of fraud or things we talked about in the last chapter and using them to obtain goods. Basically, we're saying we didn't steal it from somebody, we didn't take it by force from them, but we tricked them into giving it to us. The next one always gets people receiving stolen goods because somebody says, what if you didn't know it was stolen? Well, everybody who gets caught with stolen goods says that. You need a statute that says it doesn't matter if you knew or not, because then everybody would just say, I didn't know. Yeah.
What if you purchased it in good faith? You go to the pound.
Right. Yeah. So a lot of times in those what-if scenarios, there's a decision as to whether the prosecutor does it or not. Usually the cases they go forward are on cases like you're buying it from somebody's trench coat at, severely discounted prices. The person's looking left and right while you do it. I mean, yeah, there's certain argument that, I bought it off of eBay. I paid decent amount for it. It wasn't like it was a fraction of the value and it appeared to be stolen. I'm trying to remember a case about that. Yeah. Arson. Now that these days the statute says just, burn something. Could be your home, could be someone else's home. Those are all considered arson. Burning structures. It's really been expanded. Forgery's expanded a lot. A lot of people think of forgery as signing someone else's name to a check. But what did your book say about forgery?
The fraudulent making or altering of any writing in a way that changes the legal rights of
So if you forge, alter, change a legal document in a way that alters the duties and liabilities, responsibilities under the document, then that would be considered a forgery. So it could be much broader than that. Another way of looking at crimes is public crimes, white-collar crimes. This doesn't mean only people who are administrators in companies commit these things. It just seems like you find a higher percentage of it among them because they have more opportunity sometimes to do these things. A lot of them have to do with being entrusted or having some kind of power. So embezzlement isn't just breaking in and grabbing something. It's being entrusted with something, and then it's kind of like the criminal side of conversion, right? Like you're given the night deposit, but then you take it and do something else with it. Or sometimes this happens electronically. It could be through the mail. It could be fraud committed over the wire. Bribery. A lot of people think you have to establish that somebody did something for you. But your book talks about how just the offering of the bribe is enough. Accepting a bribe is another crime. So it's not a defense to say, well, I offered them money, some public official, corporate official, and they said no. That just means the action that you gave them the bribe for. I mean, if you pay somebody off and they don't do what they promised to do, you still have committed a crime. Or it could be, maybe you're not stealing personal property, but you could be stealing trade secrets. Or maybe using secrets to your own advantage, things that aren't public yet, and using that to trade, insider trading. Usually when I say insider trading, people think of who? But she wasn't convicted of insider trading. Yeah, well, more obstruction of justice. More if they were investigating her and she did things to hide that. So she went to prison. You can call it that. So, yeah, even if we're not able to prove that somebody acted on inside information to their benefit, if they did something to obstruct an investigation, that has a pretty serious penalty too. All right, then organized crime, as opposed to disorganized crime, right? What do you think of when I say organized crime? You think of a mob, right? Chicago. No offense to Chicago, but and sure, RICO is certainly a statute that applies to the mob, but it also applies to other types of large-scale activities where people collaborate to commit illegal acts. RICO has been applied to people who conspire to bomb abortion clinics, not the mob. You probably think, when you think of the mob, you think of things more like money laundering, which I'm always guilty of. I always leave my money in my jeans. Thank you. Taking things that you obtained illegally and putting them through some type of legitimate front to make it difficult to trace. RICO is a federal statute that has both civil and criminal penalties. You don't have to know the amount or anything. Just know that there's protection on both sides. Civil penalties could include grabbing the assets of whoever did it, forfeiture, and treble damages, where they actually come in and remove the button from your stereo. Treble. Now, treble means triple. And then potentially imprisonment. Another way of looking at crimes is to classify them by more severe, less severe, felonies versus misdemeanors. I've never met misdemeanor. I'm trying. It's a slow day. All right, so felonies, more severe. There's kind of in-betweeners. Sometimes people call that high court misdemeanor. But for your purposes, think of felonies as over a year, prison, versus misdemeanors, year or less, local jail time. A lot of times you hear that in the news, like people get them confused. They're like convicted of a felony and they went to jail for 5 years. Well, you don't go to jail for 5 years. Might feel like it, but it is possible that somebody's convicted of a felony but does do local jail time, either because they plead down the offense or they get some type of arranged sentence that involves local jail time. That's a pretty strong incentive to plead to something, is to be able to go to local jail time versus prison. Most people don't like prison. From all the people I've talked to, down with prison, they say. Well, you know what? I mean, I think initially people don't want to go there. And I think eventually most people still don't want to go there. But there are some people who can't stay away. They just like to do things to end up back there. But so without passing on any, big philosophy issues around whether prison is really that helpful or not. So you have felonies that carry a punishment more than a year. You have misdemeanors, and then there's kind of the situations where something that starts out as a misdemeanor might get elevated to a felony, like depending on how many times you do it, or the severity. Yes, so you first offense without any extenuating circumstances might be a misdemeanor. Keep doing it enough times, then it's considered a felony. Or like in the retail fraud case, it might be how much you steal, how often you steal, whether it's your first offense or not. All right, here's some defenses to criminal liability. And, some of them should sound familiar. We were just talking about them in torts. Justifiable use of force. Remember, self-defense, defense of others, defense of property. Arguing that, yes, maybe I did the crime, but I had to because I had to use this force to defend myself, my family, whatever it is. Closely related, that this idea of necessity, the action was unavoidable, I had to do it. And also closely related to that, duress, somebody forced me to do it. And when you look in your book, what does it say about duress? What kind of force are we talking about here? Yeah, like, go steal that textbook or I'll shoot you. Right? I mean, whatever you're being threatened with has to be more severe with the crime that you said that you went out and did. I mean, if I said, I'll tickle you unless you go kill someone, that's not funny. That's horrible. Right? That just doesn't, unless, I guess maybe if you're deathly afraid of tickling. I don't know. Insanity. You hear that one on TV all the time, right? Plead insanity. And a lot of times it's kind of this warped idea that whatever was done was so crazy that only a crazy person could do it. Like I had a case where Well, actually, I'll back up a little bit. I used to, the first time I was a prosecutor, they had mental institutions in Michigan. Didn't know if you knew that. Maybe some of you weren't around then. But well, I went to Western, and in Kalamazoo, up on the hill, was the Kalamazoo Psychiatric Facility.
We totally tried to break in there once.
You did?
Yeah, I'm not sure.
Right. What was the date? Who else was with you? So anyway, so our job as a prosecutor was somebody would petition to get out, and we would go represent the public and try to determine if they really, work with the court to determine if they really should be out or not. My strategy was always just let them talk, because that usually brings out whatever the issue was. And I had this one guy, he was just going on and on. But the weird thing was the whole time, kind of like this is the courtroom and see the window there beside the door, there was a guy outside the door, it was apparently his buddy, who kept flipping me off. Like really upset that I was doing this to his friend. And he was free, he was running around. And for months after that, every so often, I would see this guy on the side of the road on my way to work, and he'd flip me off. And I don't know, I didn't think much of it, but and then it was Halloween, which is weird because that's coming up. And I get a page, and I'm the only prosecutor on call, and I go down to this house, and this big roommate got in a fight with a little roommate over what TV show they were going to watch, and the big roommate bludgeoned the little roommate to death with the TV. Just basically said, I don't think so, picked it up and killed him with the TV. Now, you'd say, wow, that's crazy. But lots of angry, messed up people do things like that. It doesn't mean they suffer from a mental disease or defect that causes them either not to know what they're doing or to know what they're doing and they just can't stop. That's what you have to have for insanity. And so he got the idea, probably from the TV set that he bludgeoned his roommate with, that you could cut up the body and flush them or put them in the tub. And so he got a saw out, and I guess this is how he got caught. He started sawing his roommate up. Did anybody just have lunch? And as he was cutting through the ribs, broke off the saw blade. So he shoved his roommate into a closet, and the door was open, and you could look in there and you could see him with the blade sticking out of him. It was the guy who kept flipping me off.
The one that's dead or the one that
The guy who's dead with a hacksaw hanging out is the guy that had been flipping me off.
You win that battle.
Stories, or is this
Yeah, is this like real?
After a point, I don't even know. Like there might be hints of reality in that story.
No.
Maybe not.
He's actually the guy who looking
That's right. Anyway, so yeah. Again, that person, the defense attorney for the big roommate, did argue that his client was insane. And that's a defense, right? That's saying, okay, yeah, I did it, but the reason I did it was because I, suffered to this McNaughton test, this level of mental illness or disease or defect that the law would excuse. Remember the lady who drowned her kids in her bathtub? Arguing that postpartum depression caused her to do it and fear that they were all going to hell if she didn't. At her trial, that was the defense. And, people would say, well, you don't see a lot of other people drowning their kids in the pool because of that, or the pool, the tub. She must be crazy. Well, then an expert at trial testified that she saw that on an episode of Law and Order or something. Then she went. Well, then she went to prison and she appealed it, and then it turned out that the expert lied and that episode had never aired.
And then
Is he telling the truth or not? We don't know. What?
No, I actually don't remember that.
Yeah, it did happen. I mean, everything I tell you is true. And but then, still, whatever the motivation is, if there's people who do that, there's still some interest society has in not letting those people run around. So, anyway, mistake. Mistake isn't like, whoops, I killed somebody, I didn't mean to do it. Mistake is more like, I thought that luggage was mine and I took it, and it turns out it wasn't mine, it looks just like mine, right? So it's possible to take something and mistakenly believe it's yours. Entrapment, that was a movie. Remember that? A lot of movies are bad law, though. I mean, entrapment is more like a police agency or the government enticing you to do something you're not already inclined to do or doing. Notice the difference? Not talking about someone else enticing you to do something. And, I mean, somebody asked me in class one time, do you have to identify yourself as a police officer if somebody asks because of entrapment? I said, can you imagine that? You go up to a drug house, you knock on the door, and like, hey, I want some drugs. And they're like, are you a police officer? Oh, you got me, yeah. I'll be back again later. Yeah, I mean, but the whole idea is that you go to a drug house, you knock on the door, you're undercover, and you say, I want to buy some drugs, you give them money. That's not entrapment. You're at a drug house, right? That's what they do. Of course, the question is whether it's a drug house or not, I guess. But if they're inclined to do it or already doing it, that's different than the government getting somebody to do something they never were going to do by introducing enough money to get them to do it. Statute of limitations. Some criminal statutes have a period of time that you have to bring the action. And if you wait too long, evidence disappears, witnesses disappear, and it's just impossible to defend yourself. But more serious crimes, like we mentioned, those violent crimes, rape, murder, those don't have statute of limitations. So you have someone buried in your backyard now. There's usually not a statute of limitations in that. Immunity. Immunity is like two parts. On TV, it's always the guy in Washington, D.C. that runs a bunch of people over. Then he says, I have immunity. I don't know what accent that was, but like he just, and then they have to let him go. He says, oh, darn, you're from some other country. Keep going killing people. That's not really the way it works, right? So maybe another country has to prosecute, or there has to be some type of procedure that happens. The more common kind of immunity is like it's arranged immunity. Like you testify in this case and we won't prosecute you for something you admit you did. You have to be real careful about that one. I've seen prosecutors cut deals and then later, the person admits to things. They're like, oh, if I'd known you were going to say that, I wouldn't have granted you immunity. So you have to be careful about the scope of the immunity. Can't say, we won't prosecute you for anything you admit to. All right, now let's move to the Constitution. This usually generates lots of classroom discussion. Everybody wants to know about that time they got stopped in their car or something. So remember we were talking about the right to privacy and the Constitution, how it's not actually in the Constitution, but it comes from the Constitution. Here's the criminal side of that. If we need to search areas where somebody has a reasonable expectation of privacy, we should get a warrant. I mean, a lot of people say, well, if a police officer has probable cause, then they can search. No, the probable cause is to support the warrant, to get the warrant to search. There are many exceptions to the search warrant requirement, though. Can we come in? Something being in plain view. There's tons of exceptions to the search warrant requirement. I had a case where a state trooper stopped somebody doing about 90, and when he walked up to the car, the person had what looked like a handgun stuck between the seats. He could easily see it. So he asked the guy to step out of the car, and he said what he always said. He said, "Do you have any handguns, grenades, rocket launchers you want to disclose?" After he grabbed what turned out to be a stun gun that looked like a weapon. And the guy does what everybody says. He says, "Oh, yeah, go ahead and look through the rest of the car." Thinking that by saying that, somebody's not going to search. Well, that's exactly why they ask, so they can search without a warrant. Right? So he uncovered a metal clipboard, magnet light, flashlight, and a badge. The cop got this out of the car. What do you think he was doing? He was impersonating a police officer. Except when he stopped him going 90, he wasn't. So we really wanted to charge that, but we didn't have that. We just had a speeding ticket and some stuff like a mag. Who's got a mag flashlight here? Right? Metal clipboard. But maybe the numbers go down. But it's possible to have those things lawfully. And a badge. He apparently had his dad's badge. His dad was a corrections officer or something, retired. And anyway, so we charged him with possession of a stun gun, which was at the time was a 5-year felony, and speeding. Yes.
Aren't there a lot of loopholes for being searched though? I mean, couldn't they say that they smell drugs on you?
They smell drugs on you.
You can't prove a smell.
Well, I've been in a controlled burn.
What?
A controlled burn. Don't you know what a controlled burn is? As opposed to casual use, it's a controlled burn. Police, people. How are you going to testify that you know what marijuana smells like unless you have been, exposed to it, right? I mean, imagine under oath during a trial, you're like, well, I never smoked it myself, so I don't really know. You're going to have to be trained on how to smell it. And it's better to be trained under controlled conditions. So anyway. So, yeah, but the whole idea that, you just run around sniffing things, and that gives you probable cause. I mean, usually there's more than that's required. Like, he isn't driving down the highway and somebody flies by him and he's like, I smell danger, or, something. So usually, even the whole, request for a complaint and police report regarding operating under the influence of liquor. You can smell the odor of intoxicants, but that doesn't necessarily mean the person's drunk driving. You want more than that to go forward. I don't know if that answered your question or not. But okay. Probably doesn't get at your issue, but okay. So where were we at? So in business, right? So we're talking about individual. Kind of interesting thing about that case, the guy ended up being convicted at trial. I had to actually try the guy because he had a bunch of defenses. He argued that he thought it was a cattle prod. He argued that he was actually racing back to the police to bring it back. That's why he was going 90. But then he also argued that he wrestled it, or when he pointed out that he got it 5 years earlier, and we were trying to get him to explain why it took him 5 years to rush back to the police. He explained that actually he had been serving a divorce complaint on this guy. The guy freaked out and produced a stun gun, and he wrestled it from him, and he was now taking it back. Which, if you wrestle a stun gun from some crazy person who's going through a divorce, is the first thing you think, take it back to them? I don't know. It just seemed kind of weird. But anyway. All right. Due process, double jeopardy, and self-incrimination. Due process, we talked a little bit already in the constitutional area. It's, again, that notice that some criminal proceedings happening against you, being informed of your rights, informed of the charge, having an opportunity to object, have a fair trial by someone who's neutral, unbiased. Double Jeopardy, that was another movie. That's bad law too. You don't get to not kill your husband and then go to prison for it and then get out and go find him and kill him. If anybody saw that movie. You're not supposed to be retried for the same offense in the same court. Notice that's different than OJ, tried criminally and then civilly in a different court for a different thing. But if the prosecutor takes one shot and there's an acquittal, they don't get to say, let's try again. You're not supposed to be put in jeopardy of the same crime in the same court.
But they can go higher, couldn't they?
Well, what's higher mean? You mean like an appeal?
Well, the different, you just say in one court.
Well, what I mean is like, we talked about the Oklahoma bombing case. No? In that case, there was a trial in federal court for killing federal employees in a federal building. And then later there was a trial in a state court for killing other state citizens, in some case minors, in a different court. Those are not the same trial for the same crime in the same court. But they did that. Defense attorneys weren't happy about it because they thought they ought to bring all of the things at one time. But all right, self-incrimination. You know that you have a right to remain silent, and that includes not having to say things when you're questioned or at trial not testifying against yourself. That case I was telling you about with the stun gun, we knew the guy was going to... We just had this inkling because he said he worked on a farm. He wasn't real clear on what he had, and we just knew he was going to come out with the old cattle prod defense. Because it's not illegal to have a cattle prod, just a stun gun. So I made a motion before trial that if the defendant took the stand and testified that he thought it was a cattle prod, then I could ask him if he'd be willing to take a zap from the stun gun. Thinking there's just no, I mean, I did the motion with a defense attorney. He would clearly know what would happen if he took the stand. But he had a right not to get up on a stand and argue that or say that or anything. Well, sure enough, he got on the stand and said, I thought it was for cows. No, I didn't have to. I lit the thing up, and as soon as I did, some older lady in the jury fell out of her seat. So, anyway. He said, I said, would you like to take a jolt from this? And he said, not for $1 million. That's kind of like a TV movie. That usually, that kind of stuff doesn't happen in court, usually.
Are you trying to tell us that was another lie?
Yeah, who knows? Who knows if these cases are real or not? Does it matter?
No.
You get the point. What?
Even if it was a cattle prod, you still wouldn't want to get hit with it.
Well, they're totally different.
Oh, they are? I don't know.
Yeah. The thing is, I mean, it's a good thought. If a prod can knock over cattle, it's going to knock you over. But the debilitating effect and the amount of amperage that goes through a stun gun is different.
Okay.
Like, it totally incapacitates your nervous system. And I mean, like, the whole jury didn't even understand what a stun gun was, or that it was a felony to possess one, or the difference between stun guns and tasers and all that stuff.
Oh, okay.
So they were going to kind of probably fall into that, oh, cattle prod, that's not so bad. It still isn't that good to get hit by cattle prod. The key point was just they're going to, in the end, in their defense argue, ladies and gentlemen of the jury, you've been prosecuted for possessing a stun gun, which is a felony, and we actually possessed a cattle prod, which is not a felony. Now, if you run around zapping people with it, it can be something else, right? A battery. At the least, it's a battery. All right, speedy trial, jury trial, public trial. So the Constitution will put some protections as to how long it takes to have your trial, whether it's public or private, and whether you get a jury or not. Speedy doesn't mean so fast they mess up. It just means fast enough that you don't sit in jail and rot forever. In some cases, this isn't a footnote in the Constitution, but let me just tell you, the judge will often say, prosecutor, do you intend to ask for jail time? And if the prosecutor commits and the court doesn't give jail time, then they don't get a jury trial. In some cases, it works like that. Public trial. In some rare cases, wartime, depending on the victim, etc., you might not have a public trial, but it's very tough to exclude people, the press, from being at a trial. You should have an opportunity to confront witnesses, to have an attorney. There's prohibitions against cruel and unusual punishment. Just notice that there are two parts to that. It could actually be one or the other, too. I mean, something can be really cruel, but pretty common. Like a statute that says you treat people this way, and it turns out that that's just unconstitutional. Or it could be not all that bad, but just really strange. Like a law that says you tie people up to hitching posts at noon in the sun. Well, it actually doesn't cause any damage, but it's highly unusual. When I worked with the Department of Corrections, we'd see common ones like, you can't force me to eat this type of food because it's really, really bad, or it's against my religion, or whatever it was. All right, the Miranda rule and the exclusionary rule. The exclusionary rule says if evidence is obtained in violation of the Constitution, it should not be used at trial. So if you get evidence illegally, that doesn't mean there can't be a trial. It just means you have to prove the case without the evidence if somebody successfully argues that the evidence is suppressed. You beat a confession out of somebody. You search someplace you're not supposed to without a warrant. They often call it the fruit of the poisonous tree. If you did something illegal, then you shouldn't be able to use the fruits of that illegal search. Sometimes the issue is what somebody confesses or says, and whether they should have a right to remain silent, or if they understand their rights before they say something. That's on the next slide here. One more thing about this. Notice the third bullet says deters police from misconduct. I pose a question sometimes in my online class. What if the police beat up somebody and they confess to a really heinous crime that can be substantiated objectively outside of their own confession? It turns out that they actually did it. Should that evidence of the confession be admitted? A lot of people are like, hey, the ends justify the means. But that wouldn't deter police misconduct, because they just beat people until they got what they need and then prove it, right? So in order to deter misconduct, you put in these penalties that might seem overly severe, not allowing that confession in. Then there's Miranda v. Arizona. Yes.
So, just to verify, if you get a confession that you beat out of somebody, they get a search warrant. Can they use the evidence?
Well, this is what I would do as a defense attorney. That's the whole idea. The fruit of the poisonous tree is if an illegal activity is what you base that additional search on, and you can successfully attack that, and that warrant isn't properly supported by probable cause, I'd move to suppress that. There's no magic rules like this equals no. It's the defense attorney's burden to bring a motion to suppress and be successful in that. I went through lots of those. One I remember was a state trooper who was a friend of mine and a really good trooper. the defense attorney brought a motion to suppress because his client wasn't informed of his rights. And my state trooper swore that he read him his Miranda rights. Well, I was a young prosecutor, and I got the trooper in on the stand, and I said, and did you read him his Miranda rights? And he said, yes, I did. And I said, and what are those rights? Well, that's not what you're supposed to do. And he went, I said, are you having difficulty recalling them? And he goes, well, I always read them from my card. So he's got a card he just keeps in his pocket, in his uniform. He pulls them off and to make sure he gets them right. Procedurally, he reads them at the time of arrest to the. And I said, well, okay, well then do what you procedurally did. And he says, well, I left that uniform back in my locker. So we went on and we were successful in that motion. But sometimes the question is what procedure actually happened, and can that evidence be suppressed? In this case, Miranda isn't something that's in the Constitution. Miranda was a U.S. Supreme Court case where Miranda was not properly informed of his rights, and as a result, his confession was suppressed. Ironically, his conviction was overturned. He was let loose, and he got in a bar fight and was killed, and they read him, the defendant, his Miranda rights. How I think that's the ultimate irony there. But basically, it's saying that if you don't know what your rights are, and a lot of people are like, what do you mean you don't know what your rights are? But you need to be informed of those rights. Now, one of the common ones is when? When do you have to be informed of your rights? What do you guys think? That's what a lot of people think. It's not true.
Before you actually go to jail.
No, that's not true either.
Eventually.
If you feel like it, there you go.
Depends.
It depends. Close. We're getting there. So you put all those things together. There's two parts. Custodial, interrogation. Well, that's one way. I mean, custodial doesn't mean ask questions by the janitor. It means you're in custody. It doesn't mean arrest either. I mean, don't get me wrong. Every time a police officer arrests somebody, they're reading them their Miranda rights. So procedurally, that does happen. There might be some circumstances where it's not possible. I had a case where they raided a drug house. They hauled two guys out and put them in the police cruiser. Door shut. I'm not asking anybody to admit if they've ever been in the back of a police cruiser, but you can't get out. So they weren't in handcuffs or anything. So they're in custody. And then the other part is interrogation. Interrogation means more than questioning. Interrogation means being asked questions about the crime. So if you're driving somebody back to jail and you say, how about those lions or something, that's not a question about the crime, right? So these guys get thrown in a police cruiser, and they say, well, geez, there's no way they can get us. The drugs were over here. The guns are over here. Our bedroom's over here. Then they raided that. We were nowhere near it. They don't have any way to trace that we did this drug transaction, except they admitted to all of it in front of the police cruiser's camera. It was all videoed. Well, later they brought a motion to suppress that evidence, that confession, as being subject custodial interrogation without having the Miranda rights, right? Because they didn't. That was a situation where they're raiding, they're pulling people out left and right, they're putting them in the patrol car for their own safety, and they just spew forth a bunch of stuff. Well, were they in custody? Yes. Were they being interrogated? No. You're just dumb. They were sitting there admitting to everything in front of a camera. So they didn't win that one. All right. This is pretty much how a criminal proceeding works. It rolls out here. There's an arrest. There's a police report. That's heading off to the prosecutor with a request to authorize charges. Persons get booked. There's some kind of initial appearance. Sometimes that's the same time that's an arraignment. This is usually a time where a person is reminded of all their constitutional rights, especially the ones around attorneys, right to trial, and some question about how they plead. Not a lot of grand jury indictments in Michigan, but there can sometimes be a preliminary hearing. Usually those preliminary hearings are a lot about whether the district court has jurisdiction over something that's alleged to be a felony. So if there's probable cause to believe a crime's been committed and that this person's the one that did it, then it might be bound over to circuit court. And then it shows that arrow going over to trial. There might be some things in between it we've been talking about, right? There might be a motion to suppress some evidence prior to trial. There might be a pre-trial conference. And even a little detour here to plea bargaining, sometimes at the pre-trial conference. Plea bargaining usually is, like I said earlier, a reduced sentence or a reduced charge. And if that actually works out, then a guilty plea. If not, a trial. And then maybe, if the prosecutor meets their burden, a conviction. That's pretty much the way it works. There's a whole lot of detail that goes on about that, but any questions about this process? All right. Once somebody is convicted, either because they pled guilty as part of a plea agreement or they're convicted at trial, there's this whole idea of equal protection that we talked about earlier. What did equal protection say? No, equal protection doesn't see everyone's supposed to be treated the same. Be cool if it did.
Similar.
Right, people who are similarly situated. Well, this slide takes it a little further than that. If they are similarly situated, even after that, there's still guidelines. So just because this person I was talking about is a 5-year felony for possessing a stun gun, that doesn't mean they're going to get 5 years.